The Central Vigilance Commission can inquire into any complaint pertaining to an offence under the Prevention of Corruption Act 1988 against any Group A officer of the central government. This statement is correct because CVC inquires into PCA offences for Group A officers, that is provided in Section 8(1)(d). Second statement is Central Vigilance Commission can exercise superintendence over the functioning of the Delhi Special Police Establishment with respect to investigation of offences committed under the Prevention of Corruption Act 1988. This is also correct because CVC exercises superintendence over the CBI, which is also known as DPSC, for offences under the Prevention of Corruption Act, that is provided under Section 8(1)(a). Both of these are provided under Section 8 subsection 1. So the answer would be both option 1 and 2. Next question is, which one of the following statements is not correct? A. DPSC can investigate offences in the Union Territory of Chandigarh. That is correct. Second statement, the Delhi Special Police Establishment can investigate all kinds of offences. This is not correct because under Section 3 of DSPE Act, the DSPE can only investigate offences that are specifically notified by the central government. They do not have a general power to investigate all kinds of offences. So this would be the answer. Nevertheless, let's read the other options. For arresting a person in connection with commission of any notified offence in a union territory, the members of Delhi Special Police Establishment do not have more powers, duties, privileges and liabilities that the officers of the concerned union territory have in connection with the investigation of offences committed therein. This is correct. Next statement is, no member of the DSPE below the rank of sub-inspector can exercise in any union territory any of the powers of the officer in charge of a police station. That is also correct. Next question is, the superintendence of Delhi Police Establishment vests in, number 1, central government in all matters except those relating to investigation of offences alleged to have been committed under the Prevention of Corruption Act 1980. The first statement says the power of superintendence vests in the central government in all matters except those relating to investigation of offences alleged to have been committed under the Prevention of Corruption Act. That is correct because Section 4 of DSPE Act splits superintendence. The superintendent's power vests in the CPC for investigation of offences under the Prevention of Corruption Act, and the power of superintendence vests in the central government for all other matters. So, when the second statement says that CBC in all matters relating to investigation of offences alleged to have been committed under the Prevention of Corruption Act, that is correct. And the third statement, the administrator of a union territory in matters relating to terms and conditions of service of the members. Statement 3 is incorrect regarding the administrator. So the option would be 1 and 2 would be correct. In question 53, the administration of DSPE vests in the director appointed under the Delhi Special Police Establishment Act 1946. That is correct. Statement 2 says, director of the establishment in respect thereof has powers exercisable by the Inspector General of Police of a state as specified by the central government. That is also correct. Because Section 4 subsection 2 of DSPE Act states that the administration vests in the director who exercises the powers of an Inspector General of Police, now Director General, in respect of DSPE. So both 1 and 2 options would be correct. The next question is, which of the following statements with respect to Delhi Special Police Establishment Act 1946 is correct? First statement is, the director under 4A is appointed by the central government on the recommendations of a committee consisting of Prime Minister and a judge of the Supreme Court nominated by the Chief Justice of India. This is not correct because committee includes leader of opposition also. B, the director appointed under the DSPE Act 1946 can hold office for a maximum period of 6 years. This is also incorrect because maximum tenure is not fixed at 6 years initially. It is usually 2 years minimum. Then they get extensions. Third statement, the director can be granted extension after initial appointment in the prescribed manner. This is correct because under the recent amendment of 2021, the director's tenure can be extended up to a maximum of 5 years. First, initially they get 2 years plus 3 annual extensions they can get. Last statement, the central government can transfer the director on the recommendation of the Chief Justice of India. This is incorrect because transfer requires committee approval. Question 55. Under the Environment Protection Act, the central government has the power to direct closure, prohibition or regulation of any industry, operation or process. This is correct. Next, statement, stoppage or regulation of supply of electricity or water or any other service. This is also correct. So both the options are correct. Section 5 of the Environment Protection Act 1986 explicitly empowers the central government to issue directions for the closure of industries and the stoppage of electricity or water supply. Question 56. Failure to comply or contravention of any provisions of Environment Protection Act 1986 or any order or direction passed under it is punishable with fine extending to 1 lakh rupees. This is correct. This is provided under Section 15 subsection 1. Second statement, additional fine extending to 5,000 rupees for every day during which failure to comply or contravention of the provisions or order continues. This is correct because additional fine up to 5,000 rupees per day is provided under section 15 subsection 1. Statement 3, imprisonment extending to 10 years if the failure to comply or contravention of the provisions or orders continue beyond 1 year. This is not correct because if contravention continues beyond 1 year, the imprisonment may extend to 7 years, not 10 years. So option 1 and 2 will be correct. 57. No court shall take cognizance of any offence under the Environment Protection Act except on a complaint made by Statement 1. The central government or any authority or officer authorized in this behalf by that government. This is correct because section 19 of the EPA 1986 requires a complaint by the government or by any person who has given notice of not less than 60 days. Statement 2. Any person who has given notice of not less than 30 days to the central government indicating his intention to lodge a complaint for an offence committed under Environment Protection Act 1986. Statement 2 says 30 days, which is incorrect, so the correct answer would be 1 only. The next question is 58. Which one of the following statements is not correct? A. The Environment Act 1986 was enacted to take appropriate steps for the protection and improvement of environment. This is correct. B. Environment pollution means the presence in the environment of any solid, liquid or gaseous substance in such concentration as may be injurious to human beings. This is incorrect because the definition is not restrictive and technically not correct. The Act defines environmental pollutant as a substance injurious to the environment, which includes water, air, land, and the interrelationship between humans, other living creatures, plants, property. Limiting the injury only to human beings in this definition contradicts the broader scope defined in section 2 subsection B. Therefore, this is the correct answer to this question, as this is asking what is not correct. Remaining two, let's read it. C. Hazardous substances means any substance or preparation which is liable to cause harm not only to human beings but also other living creatures, plants, microorganism, property, or even the environment. This is correct. Next is for the purpose of offences under the Environment Protection Act 1986. Company includes a firm or other association of individuals. This is also correct. Next question 59. Which of the following statements with regard to the section 132 of Bhartiya Sakshya Adhiniyam 2023 is or are correct? Statement 1. A. A client approaches his advocate B requesting him to defend him in a case of forgery committed by him. This communication is not protected from disclosure. This is not correct because professional communication regarding a past offense, for example, defense of forgery in this case, which is already committed, is protected under privilege under section 132 BSA. Second statement, A client says to his advocate B, I wish to obtain possession of property by use of a forged document on which I request you to sue. This communication is protected from disclosure. This statement is again incorrect because professional communication in furtherance of an illegal purpose. Here, suing on a forged document is not protected. This is provided under proviso to section 132 of BSA. So the answer would be neither 1 and 2. Question 60. Consider the following statements with regard to the existence of course of business when relevant under section 14 of Bhartiya Sakshya Adhiniyam. First statement, the question is whether a letter reached the addressee. The facts that it was posted in due course and was not returned through the return letter office are relevant. This is correct, and this is also provided under illustration B to section 14 BSA. That is, posting plus not returned means receipt. Second statement is, the question is whether a particular letter was dispatched. The fact that it was the ordinary course of business for all letters put in a certain place to be carried to the post is relevant, but that particular letter was put in that place is not relevant. This is incorrect. This is based on illustration A. To prove dispatch, it is relevant to show the general course of business and that the particular letter was put in that place. Statement 2 claims the putting of the particular letter is not relevant, which defeats the chain of evidence. Therefore, option A is correct. Question 61. Which one of the following statements with regard to section 12 of the Bhartiya Sakshya Adhiniyam is not correct? A. A fact relevant as showing the existence of a particular state of mind must show that the state of mind exists generally. This is not correct, and therefore the answer to the question. Under section 12 of BSA, which is analogous to section 14 of Indian Evidence Act, explanation 1 specifically states that a fact relevant as showing the existence of a relevant state of mind must show that the state of mind exists not generally but in reference to the particular matter in question. Let's read the other options. Whereupon the trial of a person accused of an offence, the previous commission by the accused of an offence is relevant, the previous conviction of such person shall also be a relevant fact. This is correct. and this is found within the section. A is charged with shooting at B with intent to kill him. In order to show A's intent, the fact of A having previously shot at B may be proved. This is also correct and found within the section. D, fact showing the existence of any state of mind towards any particular person are relevant when the existence of any such state of mind is relevant. This is also correct as it is provided under this section. 62. The verbal statement of relevant facts made by a person who is dead is not in itself a relevant fact in which one of the following cases. A. The question is whether A, who is dead, was the father of B. A statement by A that B was his son is a relevant fact. This is correct instance of relevant fact. B. The question is what was the price of grain on a particular day in the market. A statement of the price made deceased business person in the ordinary course of his business is a relevant fact. This is correct about the course of business. C. The question is whether a given road is a public way. A statement by A deceased headman of the village, that the road was public is a relevant fact. This is also a correct instance of relevant fact. D. The statement relates to the existence of any relationship by blood, marriage, or adoption between persons as to whose relationship by blood, marriage, or adoption the person making the statement had special means of knowledge, irrespective of whether the statement was made before or after the question and dispute was raised. This is actually incorrect, and therefore answer to the question. For a statement like this related to relationship pedigree to be relevant under the exception for persons who cannot be called as witnesses under section 26 BSA or which was earlier section 32 Indian Evidence Act, the statement must be made before the question and dispute was raised, which is also known as ante litem mortem. Therefore, this option D is incorrectly stating that it is a relevant fact irrespective of the timing, and therefore this is the answer. 63. A question arises before the court regarding the existence of a right or custom where X claims fishery rights in a particular pond. Under BSA, which of the following statements is or are considered as relevant fact? 1. A mortgage of the fishery by X's father. This is relevant as a transaction by which the right was asserted or recognized. 2. X has other such rights over 3 other ponds in the adjacent villages. Generally not relevant unless a specific custom covering a group of villages or district is being proved. In the context of a specific private right to a pond, unrelated rights are irrelevant. 3. Instances where X's father exercised such right. This is relevant as particular instances in which the right was claimed or exercised. So first statement and third statement are correct. So answer would be 1 and 3 only. 64. In Chetan versus State of Karnataka, decided on 30 May 2025, the Supreme Court dealt with which of the following issues? A. Conviction based on complete chain of circumstantial evidence. This one is correct. Chetan versus State of Karnataka is a Supreme Court judgment that deals with the principles of circumstantial evidence, specifically reiterating the Panchsheel principles from Sharad Birdichand Sharda. It discussed the last seen theory, recovery of weapons, and the conduct of the accused absconding as links in the chain of evidence. The rest of the options, the importance of primary evidence in a proceeding was not discussed. The mode and extent of accepting electronic record as primary evidence was not discussed. Accepting oral evidence as secondary evidence was not discussed in this case. 65. The question before the court is that whether a given letter is in the handwriting of X, a businessman, who among the following will be considered to be a person acquainted with the handwriting of X under section 41 of BSA. 1. P, the clerk of X's business partner Y, whose duty was to examine all the files of correspondence of Y, but P never met X. This is correct. 2. Q, the gateman of X's office, who met X every day. This is not correct. 3. R, the assistant of X, who was responsible for all official communications on behalf of X and worked very closely with him in proofreading the written communications of X. This is correct. The answer would be 1 and 3 because under section 41, which was section 47 Indian Evidence Act earlier, a person is acquainted with writing if they have seen the person write, or they have received documents written by the person in answer to their own, or documents purporting to be written by the person have been habitually submitted to them in the ordinary course of business. In this situation, P, the clerk, qualifies under this condition 3, where he was habitually examining the correspondence files. Third situation, the assistant R qualifies under first and third, which is proofreading or official communications. The second one, the gateman Q, mere meeting does not create acquaintance with handwriting. 66. Which one of the following statements regarding the examination of witnesses under BSA is not correct? A. The court may, if it deems fit, draw from the witness's refusal to answer any question the inference that the answer, if given, would be unfavorable. This is correct. Therefore, this is not the answer to the question. B. Leading questions shall not be asked in cross-examination. This is not correct, and that is what is being asked by the question. It is not correct because leading questions can be asked freely in cross-examination under Section 146 BSA, which was earlier 143 Indian Evidence Act. They are generally restricted only in examination in chief and re-examination. Let's read the rest of the options. The court may forbid any question which it regards as indecent, although such questions may have some bearing on the questions before the court unless they relate to the facts in issue. This is correct. D. The court shall forbid any question which it feels to be needlessly offensive in form, even though it may be proper in itself. This is also correct. 67. Which of the following statements according to BSA is correct? 1. Dying declaration can be the sole basis for conviction. This one is correct. Because a truthful and voluntary dying declaration can be the sole basis for conviction, and this is a settled law. 2. Contents of documents may be proved only by primary evidence. This is incorrect because documents can be proved by secondary evidence where permitted. For example, lost documents. The word only here makes it wrong. Third, oral accounts of the contents of a document given by a person who has seen it will be considered primary evidence. This is again incorrect because oral accounts of contents by a person who has seen the document is defined as secondary evidence under Section 58 BSA. This is not primary evidence. Therefore, the answer would be 1 only. 68. Which of the following statements according to BSA is or are correct? 1. In a question whether a horse sold by A to B is sound, A says to B, go and ask C. C knows all about it. C's statement is not admission. This is incorrect because go and ask C makes C a referee. Under Section 20 of Indian Evidence Act, which is also there in BSA, statements by person expressly referred to are admissions. Statement 2. A undertakes to collect rents from B. B sues A for not collecting rent due from C to B. A denies that rent was due from C to B. A statement by C that he owed B rent is an admission. This is correct. Under Section 19 of Indian Evidence Act, which is also there in BSA, statements by person whose liability is necessary to prove against a party, here A versus B, depends on C's debt. All of these are admissions. C admitting he owed rent is an admission relevant against A. So the correct option would be B. 69. Which of the following statements according to BSA is or are correct? 1. Is criminal proceedings the fact that in criminal proceedings the fact that the accused is of a good character is relevant? Correct. The fact that the person accused of his good character is relevant is provided under Section 53 Indian Evidence Act, and the section is same in BSA. Statement 2. When a party refuses to produce a document which he has had notice to produce, he can use the document afterwards as evidence without the consent of the other party or the order of the court. This is incorrect because if a party refuses to produce a document after notice, they cannot use it later as evidence without the consent of the other party or the order of the court, and this is provided under Section 164 of Indian Evidence Act and BSA. Therefore, 1 only would be correct. 70. Which of the following statements according to BSA is or are correct? When the question is whether a person shown is in possession of a house is its owner, the burden of proving that he is not the owner is on the person who affirms that he is not the owner. This is correct because burden of proof as to ownership is provided under Section 110 of Indian Evidence Act and BSA. If possession is shown, the burden is on the person affirming that the possessor is not the owner. Statement 2. The burden of proving that the case of the accused comes within any of the general exceptions in the BNS is on the prosecution. This is wrong because the burden of proving the existence of circumstances bringing the case within general exception, that is self-defense or insanity, etc., is on the accused, not the prosecution. This is provided under Section 105 of both Indian Evidence Act and BSA. Therefore, only option 1 would be correct as statement 2 is wrong. 71. The match the following is correctly marked here. Examination of witness by the person who calls him is called examination in chief. B. Examination of witness subsequent to cross-examination by the party who called is called re-examination. Examination of witness by the adverse party is called cross-examination. And any question suggesting the answer which the person putting it wishes or expects to receive is called leading question. The answer is correctly marked as 2341, A2, B3, C4 and D1. 72. President of India may make regulations by virtue of Article 240 of Constitution of India for peace, progress and good government for which of the following territories? Puducherry correct, Lakshadweep correct, Chandigarh is not included, Dadra and Nagar Haveli and Daman and Diu is there. So the answer would be 1, 2 and 4. C would be the correct one. The list also includes Andaman and Nicobar, which is not there in the option. Chandigarh is excluded from Article 240 and Parliament legislates for it. 73. Which of the following statements is correct? A. The President of India can seek advisory opinion of the Supreme Court only on questions which involve interpretation of any of the provisions of Constitution of India. This is not correct. Because advisory opinion is not limited to interpretation, it can be on question of fact also. B. In a case, the Supreme Court had decided a writ petition filed by the Union of India under Article 32 of the Constitution of India, one cannot file a writ petition again under Article 226 of the Constitution of India. This is correct because this reflects the principle of res judicata. If the Supreme Court dismisses a writ petition on merits, a subsequent petition on the same grounds cannot be maintained in the High Court. C. The advice given by the Supreme Court under 143 of the Constitution of India is binding. This is incorrect because this is an advisory opinion and this is not binding. D. Article 32 and 226 of the Constitution of India are entirely identical. It is incorrect because scope of 226 is wider than 32. 74. Article 16 of the Constitution of India itself has fixed the maximum limit for reservation in matters relating to employment to any office under the state in favor of economically weaker section. This was provided under Article 16 subsection 6 that is added by 103rd amendment. While the 50% limit for SC, ST and OBC is a judicial creation through Indira Sahani's case, but this amendment explicitly states that reservation for EWS shall be subject to a maximum of 10%. And this is the only numerical limit fixed by the Constitution text itself.